Good afternoon. Welcome on behalf of the Critical Race Studies program here at UCLA School of Law. I am Cheryl Harris. I'm a professor of law here at UCLA and part of the Critical Race Studies faculty. We have a really great program today and an incredible panel, which I'm going to introduce you to shortly. But first, I want to begin with some acknowledgements. While we are meeting virtually, we are convening as part of the UCLA School of Law. UCLA is a land-grant institution that sits upon the traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples as the traditional land caretakers of the Los Angeles Basin and the South Channel Islands. We pay our respects to the ancestors, the elders, and our relations past, present, and emerging. I want to also start with thanks to our program director, Jasleen Coley, and to Annabelle Adams, Harlisha Ham, Jonathan Rosales, and all the external affairs staff that helped put this event together. I also want to thank Alicia Hawkins, our communications director. Today, we are very excited to bring you the fruits of the labor of an incredible team of the CRT Forward tracking project. That includes our project director, Taifa Alexander, our faculty director, LaToya Baldwin Clark, our fellow, Kyle Reinhardt, and Professor Noah Zatz, and our CRT Forward committee that includes myself and Professor Ahelan Arulanathan. In addition to the faculty director of the project, we are also fortunate to have the contributions of two exceptional experts in their respective fields, Emerson Sykes of the ACLU, who I'll introduce you to shortly, and Dean Jelani Cobb of the Columbia School of Journalism. Dean Cobb has been delayed, but I'm hopeful that he will join us, and I'll introduce him at the appropriate time. I first want to start out with what brings us here today. I suspect that at some time over the past maybe year, several months, each of you has heard a news report or seen something in your news feed that has referred to some governmental body, some council, some legislature somewhere, enacting or denouncing the presence of critical race theory in some curricula, some training, or some manual or materials. You may have seen politicians standing in front of a microphone decrying the corrupting and anti-American character of this CRT, critical race theory. You may have seen pictures of school board meetings where overwrought parents are shouting at each other and school board officials about the need to address the scourge of critical race theory. You may have seen pictures of people and children with signs saying ban critical race theory. You might have even seen stories about the College Board and a controversy over the development of an advanced placement course in African American Studies, where the course was rejected by the state of Florida for including so-called woke ideas like critical race theory and intersectionality. And I suspect for many of you, though maybe not all, as you've looked through the article or listened to the news report or replayed the clip, you may have wondered, what is this CRT? And why is it inundating our schools and our government agencies? For those of you who have heard of critical race theory or are familiar with it, it still might have seemed a little bit surreal to look at these reports, since for both those of you who are familiar and those who are not, the curious thing is that save for few exceptions in most of this material, you won't read anything or hear from anyone who actually writes in the area or identifies as writing in the area of critical race theory. Because in fact, in this campaign against critical race theory, this anti-woke crusade, it never actually engages the actual works or arguments of critical race theory. It's created something, it's called critical race theory. So it probably makes some sense to begin with, what exactly is critical race theory? So critical race theory is a practice and an approach to law that asks, why do we still have persistent inequality in a society that has enacted so many rules and guidance against it? Why is it that we have so many policies that oppose racial discrimination and other forms of discrimination, and yet we still have so much inequality in our society? To answer that question, critical race theory has drawn on a number of other disciplines, history, social science, psychology, to unpack how the law and the legal system operates sometimes to reproduce inequality, even when the rules of the game are formally neutral, and even when those rules or laws were adopted without racial bias. So critical race theory is focused on how racism and inequality is hardwired into our systems, both our material systems, our social relations. It's not a hunt for individual bigots. In fact, critical race theory has long rejected the notion that an individual is nothing more than their race. Instead, critical race theory is concerned with how law and policy sometimes reduces people to one dimension of their identity while ignoring others, and in the process, overlooks how we all simultaneously occupy multiple identities that affect how we experience the world and how the world perceives us. The law is a blunt instrument that too often ignores that complexity. We call that complexity sometimes intersectionality. Obscuring what critical race theory actually is has been central both to why it was targeted and why it has been distorted. The results of this distortion now extend far beyond a debate in the academy or in the scholarly journals. The results of this attack is that we are now living in a country where books and ideas can be banned in the name of freedom, and censorship can be applauded as the means to combat indoctrination, and teachers can be fired for trying to teach any idea that someone deems divisive. To help us understand where we are and how we got here, our program launched a project, CRT Forward, in January of 2021 to assess the scope and the dimensions of this assault on critical race theory in order to try to respond. The work of our project team over the last 2+ years has been encapsulated in a report that was recently released that is at the center of our discussion today. And we are excited to get into this report, which we will do with the help of our colleague and one of the lead authors, LaToya Baldwin-Clark. Let me introduce Professor Baldwin-Clark and Emerson Sykes. Professor Baldwin-Clark is a scholar of race and education. She's a former Earl B. Dickerson Fellow at the University of Chicago School of Law. She's a graduate of Penn with a degree in economics and a JD and PhD in sociology from Stanford. She writes and teaches about education, family law, property, and race. Her scholarship on some of these questions appears in leading journals where she looks at the ways in which education is often framed as a property interest to which those who are marginalized by race and class have restricted access. She's widely regarded as an exceptional teacher, and the work that she's done on this project is really central to our understanding of where we are today. Our next speaker will be Emerson Sykes, who's a senior staff attorney with the ACLU Speech, Privacy, and Technology Project, where he focuses on First Amendment and free speech protections. Prior to his work at the ACLU, he worked in the international arena, providing technical assistance to stakeholders in Africa to assist in building legal frameworks around issues of association and free expression. He also did policy work for the Ghanaian Parliament and worked locally in New York on issues of policing regarding stop and frisk. He's a graduate of Stanford also, and of NYU Law School. He was a Root Tilden Kern Scholar for the Public Interest. So let's begin with you, LaToya. Let's tell us about this report. How did this work start, and what have you learned? One of the things that I noted is that the report indicates that between January 2021 and the end of 2022, over 500 anti-CRT measures were introduced and nearly half were adopted. Can you tell us how this information was gathered and what kinds of things you were looking for? And maybe even tell us some of the things that you found surprising or interesting, and what are some of the trends? You're muted, I think.
Got it. Thank you so much, Professor Harris. And I am really excited to talk about this report, which was a long time coming with a lot of different people who are involved. So let's talk about the project itself. So with the help of our law librarians, a team of research assistants under the direction of co-authors Taifa Alexander and Noah Zatt scoured legislative records as well as media for a number of search terms that were associated with this anti-CRT activity. The terms that we looked for were not simply CRT, but also a host of other so-called divisive concepts that were lifted from the 2020 executive order that Trump put out that started all of this. For every triangle that you can see on the map, what our project allows us to do is zoom into exact measures. So for example, here's a measure from the Orange County School Board. Once the team actually identified the activity, the team then went ahead and coded each item for different information. So that includes the level of government, the type of measure, the date that measure was introduced, the progress of the measures, the types of institutions that are targeted, what the targeted content is, whether the measure targets race, sex, or also other characteristics, and what are the consequences for noncompliance to enforce these prohibitions. An important value added is that our database is consistently updated, not only with new anti-CRT measures as they come out, but we also provide an update on the progress on measures that have been introduced, but not yet adopted. Our map also includes a link to the full text of the measure. So here, the Orange County measure is another example of a value added to our database. By searching through media hits and not only legislation, we're able to capture and analyze local level activity, especially for school boards, which is where much of the activity is happening. Now, capturing local activity gives us a more comprehensive account of what the anti-CRT measures are. So while state level measures are more numerous overall, including local measures in our work helps to represent all of the places where CRT and anti-racist initiatives are being attacked. Now, we gather lots of different types of measures that is not just legislation, although legislation does make up a little more than half of all the measures we track. We end up defining measures quite broadly. Almost half of the measures are something other than legislation, including policies, resolutions, statements, attorney generals, letters and opinions, regulations, and executive directives. Why we did that is that our goal is really to provide a comprehensive accounting of the assault on CRT, which includes non-binding measures that are also designed to chill and restrict. Let me give you an example of what are those non-legislative measures. So for example, we include a Parents' Bill of Rights that was promulgated by the Indiana Attorney General's office in 2022. Now, why do we include this type of activity, even though it is not legislation? Well, because it's an official government action that here is teaching parents how to legally challenge these strained versions of CRT and CRT-inspired offshoots. It not only provides a strained definition of CRT, but it actually gives parents instruction and tools on how to challenge curriculum and teaching through things like state transparency laws, education codes about parental consent, public records law, procedural rights, and in some cases even tells parents how they can estimate damages for non-compliance of these laws. Now, let me say a couple of things about trends. So first, the measures that we look at not only name check CRT or the 1619 Project, but these so-called divisive concepts that were lifted from the September 2020 executive order. Now, although the executive order was quickly rescinded when President Joe Biden took office, the EO's language has proliferated in state and also local measures. These measures purport to ban things like saying anyone should feel guilty or responsible for the past or the present, or that the United States is fundamentally racist. But one thing to note, that all the adopted measures, at almost 50% of them do explicitly name check CRT, which gives the moniker that we're calling this anti-CRT movement. It actually means that that moniker might be accurate, even though they are attacking a very strained view of CRT that none of us would actually recognize. Another trend that we found is the issue of state political leaning. So although in 2021 and 2022, 60% of all anti-CRT measures we tracked were adopted in red states, The level at which they're adopted differs according to politics. So over 3/4 of the adopted measures in red states were actually adopted at the state level, while in blue and purple states, there is a more even split. And of course, because we are able to gather the local data, we get to see that even in blue states, anti-CRT measures are proliferating and also spreading. Third, anti-CRT measures, as many of us know, are overwhelmingly targeted at education. At least 90% of the measures that we focus on are targeted at K through 12 and also higher education. And that means that almost half of the country's 50 million public school children are affected. And of course, many more college and graduate students as well. And the anti-CRT measures overwhelmingly regulate curricular content and classroom teaching, showing that these measures are also about regulating teachers directly. Let me say a little bit about the future of our project. Now, since the start of 2023, we've seen 103 measures that have been introduced across all government levels. During roughly the same period in 2022, there were around 170 measures. However, it's important to note that because of our search strategy and how we go and looking for local activity, sometimes we're a little bit behind as to where that local activity is at any particular time. Another thing to note that's different in 2023 is that there are more measures that are restricting or revising diversity, equity, and inclusion policies. So since the start of the year, we've seen 13 measures that are targeting DEI. But this is almost as many as all of 2022 and is on pace to exceed the total in 2021. And then lastly, as many of us have heard, the measures that are aimed at K through 12 are the most common, but measures targeting higher education have increased through 2023. So far in 2023, there have been 29 total measures directed at higher ed, which is on pace to exceed the year's total for both 2022 and also 2021. So I'll stop there by giving you some of these broad trends of what we're seeing in the report, and I'm looking forward to continuing the discussion.
Thanks so much, LaToya. That's quite a lot of information to digest, and I'm looking forward to coming back to you with the opportunity to explore it a little more. Emerson, I'd like to turn to you now and ask you, as one of the lead litigators that's been involved in opposing these measures, can you tell us about the work you've been doing and how you've been approaching these cases, and maybe tell us something about some of the more significant cases to date? And it would be really helpful if you could explain the kinds of claims that the cases are raising and what rights is the litigation seeking to protect? Are these rights of students, rights of teachers? Maybe you could help us understand.
Sure. Thank you so much, Professor Harris, for inviting me and for including me in this conversation. As you noted, I'm a litigator at the ACLU. We have, for those who are not so familiar with the ACLU, we have affiliates in all 50 states, and then within our national office, we have a whole team devoted to communications, political advocacy, and then within the legal department, we focus on litigation. And I don't want to waste time with prefacing, but I do think it's important to say that my piece of this, the litigation part of it, the First Amendment litigation part of it, is one small piece of a much bigger campaign and a much bigger project, which is trying to push back against this wave of policies and legislation. So I'll focus in on the sort of legal claims that we've been able to bring in court, but I just wanted to name the fact that that is one very small piece of what needs to happen and what is happening, not only within the ACLU, but of course, across lots and lots and lots of other coalition partners. So with that, I'll focus in, Dr. Baldwin Clark talked about the emphasis on state level action. So we have chosen, rightly or wrongly, to focus on state level laws that we think that we can get courts to deem as unconstitutional. So we filed the first federal lawsuit challenging one of these statewide measures in Oklahoma. Dr. Baldwin Clark talked about this sort of 2021 wave, the 2022 wave, and now we're in 2023. Oklahoma was in the 2021 wave. It was in the first generation of these laws. We brought a lawsuit on behalf of students, teachers, and professors in higher education. The judge in that case has seen fit to do absolutely nothing since we filed over a year ago. But we have not slept. We have filed more cases. We have a case in New Hampshire. We have the case I want to focus on is in Florida. And that's challenging what's called the Stop Woke Act. This is not a name that we invented for it. This is not a nickname. This is Ron DeSantis' own name for this law. And so you talked about, Dr. Baldwin Clark, the Trump's executive order and the key phrases that were used. And so I just want to pull up for a second, if I can sort out my Zoom, to pull up just some language from the Stop Woke Act. And give me a nod if you can see this slide. Can you see it?
It's a little small.
There's a lot of text, I know, but is it not coming up in the right way?
It is, but the display looks a little small. Is there a way that you can enlarge it?
I think hold on 1 second.
Okay.
One second.
A few technical challenges.
Always. All right, let me try this one. Is that better?
No, actually, I think.
All right, look.
The earlier version.
Never mind, I'm gonna talk.
Okay.
This is why I don't do slideshows anyway. So the list of 8 divisive concepts from Trump's executive order, as Professor Baldwin Clark said, has been cut and pasted in lots of places. What's unique about the Florida law is that it applied that same list of 8 divisive concepts to K-12 curriculum, to higher education curriculum, and to employers, private employers. And it says that you are not allowed to teach these 8 divisive concepts in K-12 education and higher ed, or as a part of employee training. Our partners at another organization sued on behalf of employers, and they had the law enjoined on behalf of employers. We, along with the NAACP Legal Defense and Education Fund, the ACLU of Florida, and Ballard Spar, sued also on behalf of higher education professors and students to try to block the enforcement of the Stop Woke Act in higher education. Thankfully, we won an injunction, so the law is blocked in Florida, though it is still in effect, I should note, in K through 12. So we can, I know Professor Harris, we can come back to sort of talking about why those distinctions are important. But I think what's important to note from the list of 8 divisive concepts is that some of them are what I'd say are seemingly innocuous. So the first one, if I had the slideshow, you could read with me, but it says members of one race, color, national origin, or sex are morally superior to members of another race, color, national origin, or sex. Right? No one's actually teaching it. So banning it doesn't seem like it's such a big deal. Those are the kind of innocuous provisions. We can tell there's some dog whistling going on, but it's not as if you're actually silencing anyone from teaching anything that they were actually teaching. There are other provisions of the law that are totally nonsensical. So using scare quotes, my favorite of these provisions is the one that says that you are not allowed to, quote, teach that anyone cannot or should not attempt to treat others without respect to race, color, national origin, or sex. So if you understand what that means, you're a lot smarter than I am. I've read it.
I was just going to ask you, Emerson, if you could repeat that, because I was struggling to get my head around it.
Well, that's exactly the point. So the judge in our case said that this provision achieves the rare triple negative. It says that you are not allowed to teach that anyone cannot or should not attempt to treat others without respect to race or sex. So this is a problem, not just because of what they're trying to do, but because no one knows what it is. We actually have a slideshow from someone who's from a school district in our Oklahoma case, who put out guidance saying, all right, this is how you have to implement this law. But as to provision number 4, quote, no one knows what this means. So that's sort of an independent legal problem, aside from the misguided nature of the law, the fact that you actually don't know what's covered and what's not. Now, there are other provisions of the law that are written very broadly and very much do target things that people are teaching, right? So there's one that says that you're not allowed to teach that anyone is inherently racist, sexist, or oppressive, whether consciously or unconsciously, right? So directly getting at the concept of unconscious bias. There's another that says that you're not allowed to teach that anyone is either privileged or oppressed based on their race, color, national origin, or sex, right? Trying to nip in the bud the idea of white privilege. And even that same bit of guidance from Oklahoma, they said, to avoid contravening this law, avoid terms like white privilege or diversity. There's another provision in the Stop Woke Act, and each state tweaks the 8 provisions slightly here or there, but there's a template that they're all using. And so in the Stop Woke Act, there's one that says that you're not allowed to teach that any person by virtue of their race or color should be discriminated against or receive adverse treatment to achieve diversity, equity, or inclusion. And what Judge Walker in Florida said was, this is obviously very much targeting affirmative action, right? It's saying that you're not allowed to treat anyone adversely in order to achieve diversity, equity, and inclusion. And then there's also the one that Professor Baldwin Clark mentioned earlier, which is that you're not allowed to teach that anyone should feel personal responsibility or feel guilt, anguish, or any other form of psychological distress because of actions which the person played no part in, right? So this one is also problematic because it's saying you're not allowed to teach about racism or sexism in a way that causes anyone to feel discomfort. But the pretext, obviously, is trying to protect white children from feeling discomfort. As a Black kid growing up in public schools, I knew the discomfort of having your history erased from the curriculum. And that is not the kind of discomfort that they're trying to address with these laws. So that's just a quick, quick overview of the text.
No, that's totally fine. Emerson, could I ask you to put the slide up again? I think some folks in our audience, even though it was small, were finding it helpful.
Okay,
and we'll put
sure.
the slide in the video later, but I think it just might be useful to take another quick look.
Sure. And as I do that, let me just say that there are basically 4 claims that we have brought on behalf of students, teachers, and professors. One is a vagueness claim, which I talked about earlier, which is even sort of setting aside the substance of the law. They are so vaguely written that you can't understand what is prohibited and what is allowed. And it also opens the door to discriminatory and arbitrary enforcement because there's a carte blanche for the officials to ban or punish speech without any real guidance from what the actual text of the law says because it's so vague. So the one claim is around vagueness. We also have First Amendment claims around academic freedom, which is considered, quote, a special consideration of the First Amendment. And so there we come at the idea that we need universities to nurture new ideas, challenge norms. And it's not the role of a state legislature to reach into a college classroom and tell professors what ideas they can and cannot teach. It's one thing to say you're hired to teach history, therefore you got to teach history and not math. But it's another thing, and even for a department to say, you're not teaching according to the highest professional standards. But we argue it's quite another thing for political actors to tell professors that you're allowed to be for a certain idea, but you cannot be against it. Or you cannot advocate for affirmative action, but you can, and you are encouraged to denigrate affirmative action. And that type of overreach by those political actors, we think, is a huge problem. We also have a claim on behalf of students based on their right to receive information. So the First Amendment protects the right to speak, the right to share information, as well as the right to receive information, including in the educational context. And there is significant deference, especially in K-12, to the state to decide what's going to be in the curriculum. But even with that deference, we argue that these types of laws fail even that deferential test because these laws are not reasonably related to a legitimate pedagogical interest. Again, reasonably related to some legitimate pedagogical interest, which gives them quite a bit of leeway to put in their curriculum whatever they want, except when it's a purely partisan political endeavor that is not only not based on a legitimate pedagogical concern, but actually runs counter to all of the literature, which says that inclusive education benefits students' understanding, it benefits their academic performance, and it benefits their behavior, especially students of color. So this is in direct contravention, in fact, of the legitimate pedagogical concerns. And then the last and fourth claim that we bring is an equal protection claim, because in many of these cases, we are able to track the legislators' explicit intent, where they say things like, we're passing this law because we don't like BLM, Black Lives Matter. We're passing this law because we're sick of these woke teachers. You know, the racial animus is the grounds for its own equal protection claim, as well as the disparate impacts, because students of color are disproportionately harmed when inclusive education is withdrawn or prohibited. So those are the four claims. There's the vagueness claim, the academic freedom claim, the right to receive information claim, and the equal protection claim. I'll stop there, but happy to add more later.
Okay, we're going to come back to you, and maybe we'll see if we can work on getting that slide so that it's visible. One of the things that I think is really telling about your description of these is that on the one hand, there is some variation, but it seems as though the way you describe them, they're actually following a certain kind of template, which is actually really brings me back to LaToya to talk about some of the things that the report has lifted up. LaToya, maybe you could tell us a little bit about how your research shows the influence you mentioned before, the Trump executive order. And for those that don't know, kind of if you could tell us a little bit about how the report sees the relationship between the Trump executive order and the sort of current, I guess I would call them, models of legislation that Emerson is describing that are being challenged.
Sure. Let me take, I guess, in answering that question, I'll just take a little bit of a step back to explain even how we got to this point, right? And so we have this 2020 executive order that was released in September by Donald Trump. And this wasn't something that he just thought of on his own. There were many conservative organizations and people who were pushing the Trump administration to do something along the lines of what they did. There is a conservative strategist named Christopher Rufo, who really is thought of as being the person who really spearheaded this effort. He saw in the summer of 2020, when organizations were starting to change, put out statements, do resolutions in response to the murder of George Floyd and also Breonna Taylor, it really implored the president to do something. And this happened on Fox News, of all places, in September. And when he issued this executive order, as Emerson was talking about, the executive order really only were focused on federal trainings, but had all of these different types of divisive concepts that Emerson was speaking of. And what's really fascinating about this is that this came out in September 2020. Trump lost the election in November 2020. Joe Biden took office in January 2020 when he rescinded the EO. But the way that we've seen it is that the EO had already done a lot of damage. And it had done the damage that Emerson is talking about, not only in the first wave in 2021, but also in 2022 and now in 2023. And so the way that the project sees this is that it has gone beyond that the 2020 executive order, and now it's including other things that weren't there. And so I think it is right to see these as different kind of waves of movement. One thing that I think we're also going to see in the future are what I would call second order measures. So these are going to be measures that the state is going to put onto school districts that says, give me an accounting of every single dollar that you've spent on DEI. Who did you pay? Why did you pay them? What has been the outcome? So in these very bureaucratic, burdensome ways of trying to get school districts and teachers to not teach CRT or anti-racism because they don't want to then be subjected to all of these procedural, bureaucratic requirements going down the line. And so, you know, that's one thing that I see is going to be coming up soon. Another thing we're doing with the project is trying to also in the future track the litigation that Emerson is talking about, but also litigation that's being brought by other institutions. We're writing things like model legislation where we can have a piece of legislation that is not necessarily quote unquote pro CRT, but pro teaching history accurately, pro teaching about racism accurately. We're also working on model school board policies. So if there is a school board that wants to kind of head this off or wants to actually engage in thinking about CRT, we're going to have these policies that school boards can kind of pick off the shelves and put their own information in it in order to fight CRT going forward. I think that those are kind of the big things that we're looking at. And of course, the project is going to continue to track all of these anti-CRT measures. Again, this has not slowed down in 2023. We're going to continue to see a lot of this. And part of our project is to really provide a comprehensive account of what this movement is really looking like. And then, of course, working with organizations like the ACLU, like the African American Policy Forum, working with other organizations who are also doing this work and hoping that our data and our database are going to be helpful, not only to, of course, law professors, but helpful to people on the ground, advocates and activists, even individual parents and school boards, to give them the tools to be able to go out and really mount a mass resistance.
Thank you. Emerson, I do want to come back to you again because I don't necessarily want to get way down in the weeds, but I think it would be really helpful because, you know, when you actually look at some of the language of these laws, I think you've put some of them in the chat there, and they look like such obvious examples of censorship. You know, the kind of thought suppression that most of us think shouldn't be legally permitted under the First Amendment. I mean, I'm looking at this language that says that if a person is meant to feel guilt or anguish because of actions, that actually becomes a violation of the provision, that something that is deemed to be divisive, a divisive concept, can actually trigger some kind of sanction against an individual or a school district. So it would seem that, you know, students should have the right to access basic information that shouldn't be subjected to these kinds of unreasonable or vague restrictions. And certainly teachers shouldn't be threatened with some kind of sanction as a result of teaching something that somebody decides is divisive, especially, as you said, where there's no obvious pedagogical concern that's going on here, but really more like political motivations. And I noted that a recent news report talked about that, you know, despite the ever-growing number of restrictions, there are relatively few lawsuits. And I know the ACLU is not, you know, the only entity that is sort of taking this up, but it really struck me that these laws just, you know, just to the sort of, I guess I would say, general perusal, they just look wrong. And so the question is, why has there been a challenge in sort of bringing these lawsuits? What are some of the challenges I think that you may have encountered, and why do you think it's been the case that despite the proliferation, we've got, you know, over 250 of these kinds of laws, some of which look patently wrong, unconstitutional, vague. Why is it so hard?
I appreciate the question. I think there's a few reasons. One, I would say, is the doctrinal issue that I mentioned before, which is that courts really are hesitant.
Emerson, could you lift your volume just a little bit?
Okay, can you hear me?
Yeah.
Yeah. I think courts are generally, and for some good reason, hesitant to get involved in regulating what kinds of lessons are included in state curricula, right? It has to be relatively egregious for a judge to say, I know better than the education officials who are making these choices about what needs to go into the curriculum. We point out, though, that it's not the judges questioning the departments of education, because in many places, the departments of education have their own DEI statements, they have their own inclusive education curricula. It's the legislators, it's these political actors who are trying to score these points, who are trying to enforce these rules at this point. But there is this sort of fundamental issue that at public schools, the government creates the curriculum, right? And so in order to get a judge to say that they have stepped out of line, you have to have very egregious language and egregious facts on the ground. And so that's especially true in K-12, where the courts think about the importance of protecting students from indoctrination. It's mandatory that they are there. They are captive audience. And so the legal system is very protective, especially of K-12 students. In higher education, we argue it's quite a different picture, right? Everybody involved are adults. They go there not because they are sort of mandated as a part of the state's curriculum, but because they go to study with professors like Professor Harris and Professor Baldwin Clark to learn from their expertise, to take seminars that dig deep into innovative new issues. And so in that context, the idea of regulating what ideas can be presented, we think is much more problematic, and why we think we, in many ways, have stronger arguments under the First Amendment in the higher education context. Even that said, academic freedom is cited by the Supreme Court. They say that literally the fate of our democracy rests upon academic freedom. There's all this lofty language about the importance of academic freedom and how fundamental it is, but I call it the cotton candy doctrine. Because once you really start trying to chew on it and figure out what it actually entails, the courts have not said a whole lot about what it actually means. It's not mentioned in the text of the First Amendment. And so when it really comes down to what is academic freedom really, and what are the limits of the state's authority to regulate public higher education, a lot of these questions are open. I agree with you, Professor Harris, that they don't pass the smell test. I always appreciate when we can bring a case that my auntie can know immediately is ridiculous. But at the same time, when legal scholars who've been studying these things for a long time acknowledge that many of these questions are open, and these are some novel arguments that we're trying to make. So for those reasons, these are challenging cases, even when the language is quite egregious. And of course, another thing is finding people who are willing to stick their necks out and be plaintiffs. Mm-hmm. With Ron DeSantis going on TV every day, coming up with new and innovative ways of trying to chill speakers and intimidate educators, it's not surprising that we had to work very hard to find brave professors who are willing to put their names on a challenge like this, and students as well. So finding plaintiffs, even the number of people who are horrified by these laws, who are concerned about these laws, who are changing their behavior even because of these laws, is extensive. But the number of those folks who are also willing to put their names on a federal lawsuit is understandably quite small. And of course, there's also the issue of the federal judiciary. And sort of, it's no secret that we are facing an increasingly conservative bench. And so we also have to find ways of, making the arguments in the most honest way that we can. The fact that these are attacks on Blackness, they are racist attacks, while also formulating our arguments in ways that we can convince judges right now that don't agree with us that this is unconstitutional. Right now, we're in the 11th Circuit, which is, covers southeastern United States. It is a notoriously conservative circuit court of appeals. And we're there trying to convince them that this law is unconstitutional. So we're not, not leaning away from the racism that's underlying these things, but we also need to be able to appeal to people who may not agree with us on that fundamental principle, but we think we can get them on our side with the basic idea that the legislature should not be telling professors what to teach, that they can teach that they like something, but not that they don't like it. And especially, in parentheses, given how much ink has been spilt on the political right about the importance of academic freedom and protecting conservative professors, that we think that we can sort of show that back to them and say, we agree that academic freedom is important, and even if you don't like these ideas, they need to be protected.
Yeah, I think that's an interesting point, because indeed so much of the debate has been about the degree to which conservatives feel themselves to be silenced in the context of higher education, and feeling as though certain ideas have been taken off the table. What's really stunning about things like the Stop Woke Act is a sort of blatant effort to basically make certain ideas unteachable. And so that is, in fact, a very clear double-edged sword. What I'm interested in also, though, in thinking about, LaToya, some of your comments about the sort of trajectory of how we got from the Trump executive order to where we are now, is that process in the middle. Unfortunately, Dean Cobb hasn't been able to join us, but it's that way in which the media coverage of this question, I fear, has also contributed to the problem, to the extent that this way in which CRT has been kind of hijacked and captured in this moment was really very explicitly stated as a project of one of the architects of this proposal, and that's Christopher Rufo, who you mentioned, LaToya, who publicly acknowledged that part of the project was to take the brand and make it toxic. So that's kind of really fascinating when you have somebody explicitly telling you what we're about to do is actually engage in disinformation. And yet the media has seemed to be unable, even though it reported it, unable to effectively counter it. It reminds me a little bit about the ways in which the whole narrative regarding the election fraud, despite the fact that there was virtually no evidence of any such fraud, nonetheless took on a life of its own, separate and apart from the facts. And even though the media was ostensibly reporting that there was no basic evidence, somehow the reiteration over and over and over again of even election fraud in quotes nonetheless seemed to take off. In one way, it sort of makes me think that one of the problems that we have here is the way in which sometimes the media coverage has reduced itself to a sort of he says X, she says Y, a kind of leave it to the reader to figure out who, what the right parts is. And it also basically means that this disinformation is reinforced. I was thinking about what you were saying, Emerson, as the dilemma here is in the context of higher education. As I understood what you were saying, is the claim is, look, the legislature should not be censoring what professors can teach in the classroom. And if they're choosing to teach critical race theory, just like if they're choosing to teach behavioral economics or any other body of work, that should be covered by academic freedom. So the actual CRT is what's being attacked in that context. But in the K-12 context, it's a kind of boogeyman. It's a made up version. Nobody is teaching this version of CRT, and yet it's all traveling under the same sort of umbrella heading. What I want to do before we turn to questions is also just ask if either of you have any other comments or things that you'd like to bring forward, and then I think we're going to open it up for questions if I'm looking at our time right here.
No, I'd love to go right to question and answer.
Okay. All right. Do we have any questions that I guess what would be the best way for me to proceed here? All right. Well, let me just go to some of the questions that are in the chat. How about we start there? Okay, this is quite quite a list of questions here. Let's ask this. This one is directed to you, LaToya. You've argued that the parents' rights movement combines a psychological proprietal interest that parents think they have with kind of top-down political expediency. Has this changed since the early attacks starting in 2020? And what is the best way to sort of frame a challenge, a legal or textual challenge, and shape the public discourse against these measures on curricular control? And sort of what are your thoughts about how this intersects in some ways with some of the work you've already done?
That's a big question. And so I'm going to try and take a piece of it. So yes, my work in the past has looked at parental participation and the ways in which parents use their role as parents in order to make changes in the school districts and in schools that are favorable to their children, but not favorable to other children. One of the ways that I think that the parental participation is playing a huge role here is Professor Matthew Shaw talks about the idea that we need to separate the idea of children and students. So while a parent may have has control over their children, we need to think about what is the state doing to its students and understanding that sometimes those things are going to conflict. But we need to always be thinking about the state's role when it comes to education and how they are actually educating students and not always thinking about them as the purview or the property of their parents. And how do I see this? I think that the idea of parents' rights has been around obviously for, hundreds of years, especially going back to the 1920s, where the Supreme Court actually told parents that they do have a right to have some say over their children's education. But one of the things that we do know is that parents' rights are and have always been raced in a certain way, that there's always been the case that when parents' rights are championed in racially regressive ways, they're not actually talking about all parents. They're talking about a subgroup of parents who then want to make decisions about how other people's children are actually educated. And so I see this as a further example in the history of how parents are used for racially regressive means that hurt all of us, hurt all children, and in ways that I think that we should be very suspicious of when it comes to the role of parents in schools and the obligation of the state to educate its students.
Do you
Can
have
I
any
just
thoughts on this, Emerson?
Sure, yeah, and just can you hear me
Yeah.
clearly? Good. I switched microphones. Just going through the chat and then responding also to what you were just talking about, LaToya. I think, we think about parents, we think about students, we think about teachers, and then there's also a question about attorneys, what we can do. And I think when it comes to parents, the ACLU has been among the many advocates who have been advocating for transparency and participation on behalf of parents. But what a lot of these laws are doing is giving individual parents a veto over what everybody else can learn. So it's not about controlling your own child's education and deciding what they should or should not participate in, but it's about barring what everybody else can see and learn. And we've seen this especially in the related but somewhat separate context of book bans, which we talked about a little bit, Professor Harris. Efforts to ban especially LGBTQ, but also race-related books. And there, it's not just saying, I don't want my kid to read this book. It's saying, I don't think it should be in circulation and nobody should have access to this kind of information. And that is a real perversion of the parental rights, I think. We have, a lot of focus has been on sort of parents versus teachers and parents' rights versus teachers' rights. I think teachers, and my wife is a teacher, my parents are teachers, my brothers are teachers. I have a lot of love for teachers, and I know that they're really at the sharp end. They're the ones who are suffering the most because they are, caught between, wanting to teach according to their best knowledge and understanding and expertise, while also fearing the repercussions if if many or maybe just one parent or student complains. So they are in an almost impossible situation. And so I always like to include in these talks that the best thing we can do is hug a teacher and be supportive to teachers, because it's really a hard environment for them. But I think what we want to keep the focus on is students, right? And instead of trying to get into a parents versus teachers debate, it's really about protecting the education of students. And they are the ones who suffer as we play this sort of political football with their educations. And instead of relying on the education research, which it reinforces the need for a more inclusive curriculum, to tell a variety of narratives, to encourage critical thinking, instead, what we're trying to do is score political points by shutting off certain types of discussion that these politicians don't want to hear. So what can students do? What can teachers do? What can lawyers do? I think there's a lot of great organizations that are activated in different ways in terms of going to hearings. So we've been successful. I think it's important to remember that we do have some victories. We blocked the Stop Woke Act. We've had many of the book bans reversed, even just through threats of litigation. They bring back the books onto the shelves. We've seen, even in places like Florida, parents showing up to school board meetings and letting their voices be heard, and school boards actually deciding not to remove books that they were considering removing. I don't want to paint too rosy a picture. I think in general, we're seeing a negative trend, but we do have some victories that we can build on. And so I think there's a lot of action that we can all take outside the courtroom. As I said, the litigation is one very small piece of this. There's so many other things that we can do with, putting our bodies in spaces where they need to be, supporting the people who are most under fire, and also in, teaching our children in a way that we think is going to benefit them the most.
Thank you for that. I really was thinking about your point about focusing on the students. And even though I know, as you've explained, that there's a lot of headwinds, I guess, shall you say, in making certain kinds of arguments, because under public education laws in most states, the state does have the right to sort of set the parameters of the curriculum. But I was thinking back to a kind of prior moment where we saw an earlier iteration of this kind of anti-antiracism campaign, and that's going back to Arizona several years ago, where the state basically passed legislation which was designed to ban ethnic studies program as a result of, I guess, a controversy that arose out of the Tucson district, which had been adopting a Mexican-American ethnic studies program at the high school level that Republican politicians found offensive and sought to ban. And I note in that case, it's Arce versus Douglas, I believe, that the court talked about the fact that the problem with this law, in addition to some of the things that we've obviously mentioned in terms of it being somewhat vague, was that it really seemed to impinge upon, and in certain ways, really, there was no proof that the courses that were being taught actually had contributed to any disharmony or were otherwise harmful, and that there was a way in which it was restricting students' access to materials, a kind of, I guess I would call it kind of almost, it seemed to be articulating a right to access certain kinds of information, or a right to learn, or freedom to learn, or something along those lines. And I realized that obviously, the doctrines in these areas that you talked about don't really have clear contours. Of course, very little around First Amendment law does. So I just wonder if you have any thoughts about what that line of thinking might do if, in fact, we were to say, if we focus our attention on what is happening for students, might that not be a kind of link, I guess, to a more expansive kind of understanding of what it is that we're trying to protect?
Absolutely. And I saw there was a question about sort of decentering teachers. I think you're right to point to Arce v. Douglas. It's an extremely important case that established clearly the right to receive information and sort of against partisan, political, racist attacks from the legislature. We rely heavily on that case. And I will say, Unfortunately, there aren't many other cases like it. So there isn't a huge body of case law that acknowledges that right. But I will say that in all the cases that in the New Hampshire case and in the Florida case, one of the sort of more subtle victories that I can mention is that we have more citations to Arce v. Douglas. So those are judicial opinions where the court recognizes the right that was recognized in Arce v. Douglas. And the ACLU has been around for over 100 years, and sometimes we get big wins that make the headlines, but just as often we chip away at the doctrine over years and years and years, and briefs and briefs and briefs, to try to get something from a footnote into the last paragraph, into the front of the paragraph, and finally maybe we get a decision based on it. So I think that is an example of how we're trying to build out that doctrine and also trying to define some of those contours. I would just also add that in terms of the teachers, it's not that we de-emphasize teachers. Teachers are plaintiffs in all of our cases. They are central. They are the ones who know about the regulations. They are the ones who are being punished for not abide if they run afoul of these regulations. There was a question about whether students can also be punished. Generally with the curricular work, not so much, but you could imagine a situation where these things could be twisted and enforced against students. The other complication I would just mention with regard to claims on behalf of teachers is that they are public employees at work. And the First Amendment does not provide full protection to public employees, that is governmental employees, who are in the course of their jobs, right? You don't get to say whatever you want if you work at the DMV counter. You got to do what the DMV tells you to do. So, likewise for police officers, they're not allowed to express their personal opinions. They're not supposed to on the job, right? Now, teachers are obviously different in many ways from DMV employees or police officers, but courts have said that at the end of the day, they are subject to at least generally similar rules in terms of not having a real First Amendment interest in delivering the government's curriculum. As I said, I understand education from my family in such a way that there is incredible amounts of creativity and skill and individual influence on behalf of teachers, but courts don't really recognize that. And so bringing claims on behalf of teachers, primarily we bring vagueness claims on behalf of teachers, right? Because if they don't know what the rules are, then how can they teach according to the rules? But that's different than saying they have the right to teach whatever they want and the government can't infringe on it. Because at the end of the day, they don't really have the right to teach whatever they want in public schools. Professors, we think, maybe not whatever they want, but we think that there is significant more latitude for professors in higher education to create their own syllabi, to create their own courses. They assign their own books oftentimes. And so it's a different kind of endeavor, but it is a complication.
I appreciate that. One of the questions that's come up in the chat, and LaToya, I guess I'm pitching it to both you and I, although Emerson, if you have any thoughts on it, it'd be great. One of the questions is that in previous discussions, it was suggested that it was perhaps unstrategic to suggest that CRT wasn't being taught in schools. However, the questioner asked, you now suggest that in K-12 schools, no one is teaching, quote, this version of CRT. Are you recommending drawing attention away from CRT being taught in K-12, or are you recommending acknowledging that CRT is being taught, but not the toxic version suggested by Rufo?
I definitely have ideas about this. I actually think that the two options being given are actually not kind of what's happening. I don't think that it is a good strategic move to say CRT is not being taught in schools, because I think it's besides the point. The issue is, can children learn about race and racism, both in the past and contemporarily? Can they learn about those things in school from an accurate and truthful point of view? right? So whether CRT specifically is being taught in schools or not, one thing to note about these bans is that they aren't just attacking CRT. They're looking at these other types of divisive concepts, such that, you know, it doesn't make sense to only say that this is about, is CRT being taught in schools or is CRT not being taught in schools? We have to understand the challenge for what the challenge actually is. It's not even necessarily about being against CRT. It is really pushing back, I would say, on many of the racial demands for justice and equality that came out of the 2020 uprisings, the 2020 revolutions after the passing of George Floyd and Breonna Taylor. And so looking at it in that context, I think we need to understand that this is really about resisting racial progress, not necessarily about CRT or even the 1619 Project or et cetera.
Right. So in some ways, what is labeled CRT, I heard a commentator describe it the other day as is a kind of piñata into which has been placed all forms of ideas, including even, and I saw this in one of the questions, social and emotional SELS. So, help me out, folks.
Social emotional learning.
Thank you. Look at that. So I think that one of the things that is really telling is that in this context, CRT has become a label for any idea that has associations with anti-racism, has any affiliation with, and in that context, from the legal standpoint, Emerson, it's kind of a huge container of ideas that are being taken out of the curriculum, or at least targeted within the curriculum. One of the things that I also wanted to lift up is there's a question here about whether in the future will the CRT Forward project have a section dedicated to tracking DEI measures or attacks on DEI, or is this just going to continue to be incorporated into the overall database, or will there be a kind of, I guess I would say, that you mentioned before that this seems to be the expansion of the frontier, so to speak. So how would you envision that the project is going to be tracking this going forward?
Sure. So part of the strategy of the database itself is to look at these local level things that are happening on the ground. And most of the time that's coming out of local newspapers, et cetera, for us to learn about this. And so what I imagine going forward is that now that our database is set up, that we will start to include other types of what we would call anti-CRT measures that maybe are on this second order or not necessarily explicitly about CRT. Like I said, in 2023, we are seeing an uptick on attacks on DEI in particular. And I think because of that, it is going to force us to make sure that we are accounting for these attacks on DEI in a way that maybe our database is not doing. But that's the great thing about our project, is that it can continue to move and grow as we learn more, as these attacks become more multifaceted. We now have the infrastructure to continue to do this type of tracking of different things, going deeper into our coding. We actually have the ability to do all of that in the upcoming 2023, also through the 2024 elections, because we do know that this is part of the strategy as well. Part of the strategy has been, we are going to keep this top of mind for our base when it comes to the 2024 election. And so we're going to have all these opportunities to do more of this work going forward. And that's a great thing for our students too. We're trying to get students as involved in this as possible. The fact that this is happening even more, really great pedagogical tools for us as faculty.
Yeah, one of the, even though it is quite horrific in terms of its effects, one of the things that's quite powerful is actually thinking about the focus of critical race theory on how the law can participate oftentimes in reproducing certain forms of inequality. This is actually a prime case study of how that can be done. In other words, there's a kind of critical race theory analysis that might be available to look at the attack on critical race theory. I mean, that may seem to be, a couple of levels out, but one of the things that I think is really important to recognize is, and it's something you mentioned, LaToya, that this particular movement comes out of a certain context, which is the context in which we had one of the most, vibrant and large social movements demanding for a broader, deeper understanding of racism, a movement that brought the language of structural racism into the discourse. And now what we're seeing is an effort to beat it back. What we're seeing is an effort to say, no, we actually don't want anybody to sort of engage in this inquiry. And of course, at the heart of this movement has been young people's demands for this information and young people's demands for this kind of education in the first place. I know that we followed, and I know the team did as well, one recent, I guess I would say about a year ago, where there was a local school board that was taking up an anti-CRT initiative. And it was the young people, it was the high school students that were basically, and I think Emerson, you mentioned the case as well, where the students themselves were at the lead of resisting this and saying, no, we actually want this information. We actually don't want to be censored. We need this information because it's actually going to help us as we go forward, trying to build our way and trying to build a path towards a better sort of democratic process and ideal. I think we're coming to a close here. I don't know if there's any other question that I can lift up that we could address in the couple of minutes that we have. One thing I did want to do is give you guys an opportunity to, take a minute to close off, and then I want to share a little bit of information about both the project and a couple of events coming forward. Any closing remarks?
Emerson, would you like to go first?
Sure. I mean, just to echo what you were just talking about, I mean, we at the First Amendment team within the ACLU spent a year and a half doing protest cases, representing anti-racist protesters. And it's not a coincidence that I've now spent most of the last year and a half dealing with the backlash. And it started out with us trying to avoid adopting the mischaracterization of CRT and saying, well, we're not going to just adopt that label. But the truth is now in the Florida case, the people that we're representing are professors who teach critical race theory, critical gender studies. This is actually an attack on CRT. As you mentioned, it's a complicated dance to try to not sort of step into the bucket that Chris Rufo has set out for us, but also acknowledging the real impact that it's happening across the board. So I really appreciate the opportunity to join this group and look forward to working together in the future to try to make a little bit more progress.
LaToya?
Sure. I think the last thing I'll say is, as one of the co-authors of the report, read the report. You can see a lot more about what it is that we're doing. I was able to highlight only a few trends, but the report gives you so much more information about how it is that we gathered our information, what are the trends that we're looking at. And we also do some work. I do want to lift up. We also do some work there to show that this is not only about race, right? So we are seeing that these kind of attacks are also happening against LGBT folks, not in our schools. And we kind of labeled that as, first they came for this and now they're coming for us. And we would be remiss not to note the ways in which the anti-CRT movement and the anti-LGBTQ movement are working in tandem when it comes to these bans at this time.
Thank you. I want to thank everybody for attending. In the chat, you will find the link to download our report and other resources, and also a link in which we invite you to contribute and donate to our program so we can carry on this work. Finally, I also want to note that on May 3rd, which happens to be Teacher Appreciation Day, Emerson, there is a National Day of Action on Freedom to Learn. A link to the African American Policy Forum is there. You can register for Freedom to Learn National Day of Action. We're calling on people to read banned books, to have teach-ins, to really make our voices known in pushing back against this effort at muzzling and censoring our ability to name our reality. Thank you so much for joining us, and I really appreciate all of the help that was done in putting this event forward. Thanks again, Emerson, and thanks, LaToya.
Thank you so much. Ramadan Mubarak.
All right, thank you.
Bye.
Thank you.